Tuesday. Thank you so much for joining us on Mansfield today. And on Tuesdays, we delve into matters legal. Our resident legal expert is Advocate Lance Brogden, who is a legal and strategy advisor and expert as well. You don't mind if I call you Lance, do you?
I do, Jeremy. I take umbrage. This is a very professional show.
Fine. So. Then you can call me Mr. Mansfield.
With pleasure, Jeremy.
Nice to have you with us, Lance.
Thanks, Jeremy.
Let's bring it down to earth here for earthlings like me, as opposed to lawyers like you.
Thank you.
Where does our law come from?
Well, we have, Jeremy, what we call a mixed or hybrid legal system, influenced by the colonial taking into all the countries in Africa and the world, and the legal systems came with them. So primarily we have a Roman Dutch civil system, and then later when the English came into South Africa, they brought the common law system, the English common law system. However, we have also embraced over time what we call customary law, or better known as African customary law. So all three are integrated into our legal system and protocol.
What individuals then make up the legal fraternity?
We start with saying there are a very broad spectrum of people, but directly called lawyers, which I'll get to later on. We have judges, magistrates, we have advocates, we have attorneys, but very important as well, we have a lot of other players in the legal fraternity. So, for example, we have a judge's clerk, we have sheriffs who go and issue summons, and so on and so forth, even down to the policing. Police are part of the legal system broadly.
What is the difference then between a lawyer and an attorney?
Okay, this is it's a global question because both are often used. So, a lawyer is a person who is legally trained. So we are all lawyers. An attorney is a practicing attorney who is registered to practice and to appear in court and represent his client. But generally we are all lawyers. Whether you be an advocate, attorney, a legally trained person is a lawyer.
Okay, but then explain something to me then. If we've got all these written laws, why do we have court cases? I mean, why don't we just apply the law as it's written there? I mean, that to me is simple.
I wish it was that simple. Yes, where the challenge lies. We have a situation that arises where interpretation of the law is important. The one part is the interpretation, and you have to interpret a number of components, from the statutes, the written law, through to precedent, cases where decisions were made on interpretation. Actually, those can be overthrown in later cases, but that becomes the reference for law. But there's another reason why we have cases. We need independent parties measuring and making decisions on the outcome of a legal incident. So it makes sense to say, well, we just read the law and you right and you wrong. But then who's going to do that and who's going to interpret it? And for that we need lawyers and a legal system to go through that. Every party has a fair chance of putting their position on the table, and that is why it's more than just reading the law and answering it just like that.
Okay, right. You've justified your job.
Thank you. It's taken me 30 years to do that.
What are the primary different types of courts that we have in South Africa? I mean, I know you've got a magistrates court and a high court.
Sure. So the highest court is the constitutional court.
Of course, yeah.
And as we know, there are many challenges about that and the constitution and the rule of law and so on. But then you have the high court, previously called Supreme Court. You also have the higher court of appeal based in Bloemfontein. But then you have magistrates courts, but there are many other courts. I mean, we can go through, there are special courts for labor, small claims court. You've got a small claims court. Under a certain quantum, people can approach that court. There are children's courts. So there are many, many different types of courts. Important thing is that depending on the matter at hand, it is heard by an appropriate court with appropriate people sitting on that bench, making decisions about the outcome of that matter. So they are different, and there are different skills involved.
Okay. Right. Now, I've got a legal problem.
Yep. You only got a legal problem. Jeremy. I wish it was that simple, my friend.
I've got a legal problem. So I approach my attorney.
Yes.
And I explain the legal problem to him. And he then takes it to an advocate. And why? I mean, he's trained. Why doesn't he do his job? Why does he then go to an advocate?
Well, I'll tell you what.
Yeah.
Why don't we zoom out and go ask a practicing attorney?
Okay.
So I think then you hear it from the horse's mouth. At what point and what time he or she approaches an advocate for counsel, for advice. So let's go across.
Okay, to Dolph Base. Dolph, thank you for joining us on Mansfield today. Give us an answer to this particular question that's been posed.
Morning, Jeremy. Morning, Lawrence.
Morning, Dolph.
Thank you for the opportunity to be on your show. Yes, a client will generally approach an attorney to make an informed decision regarding further conduct of his case. And a good way that I find to explain this is that if you feel sick, you will generally approach a GP. You'll go to your local general practitioner, who will then look and examine your problem. And if he feels there's something serious that you need an operation, then he'll refer you to a specialist surgeon. If it's a knee problem, it will be a knee surgeon. If it's an eye problem, it will be an eye surgeon. And it is quite similar in law. A client will approach an attorney with a specific problem, and the attorney will do a consultation with the client and examine the facts. And if he finds and the matter is complex, then he will refer it to an advocate with the amount of money that's in question and the complexity of the matter. Once an attorney refers the matter to an advocate, the attorney and the advocate will have an interview or consultation with that advocate, who will then make a recommendation. After that point is reached, it is a little bit different to a GP and a surgeon, because the attorney and the advocate then works together as a team, and they have very different roles. The attorney will generally draft all the correspondence, and he then becomes an administrator. If the matter is very complex, the advocate will draft the formal pleadings, and the attorney is then responsible for the service and the filing and the communication with the other side. When the matter has to go to trial, there is a lot of legal work, administration. It's reams and reams of paper and procedures that needs to be followed. The matter has to be uploaded onto case lines, and you have to prepare trial bundles, pleadings, notices bundles, correspondence bundles, all that administrative part. That is the role of the lawyer. He then prepares the boxer for the ring. He makes sure everything's in order. He consults with his client, with the advocate, who prepares the client as a witness, and if there are other witnesses, the attorney and the advocate will deal with these witnesses, and then the advocate will then research case law, and he will actually argue the matter in court. And the attorney will sit next to him and assist him if there's anything administrative that needs to be done, in a nutshell.
Okay, Dolph, thank you very much for your time. Thank you for joining us on Mansfield today. That is Attorney Dolph Bass, who prepares. He's just referred to you as a boxer.
Trust me, we've done matters that has required a lot of boxing.
Finally, just to wrap the conversation up for today, if a person has, or a company for that example, has a legal matter, what do they need to bear in mind as they approach it?
Let me give a few points, Jeremy, if I may. So the first one is, when we mention all these different courts, we have different parts of the law. Choose an attorney that specializes in the area of your matter. People think because one studied law and is a lawyer, one knows everything. No, people specialize. If it's a matrimonial matter, you'll go to a matrimonial attorney, family law attorney. If it's criminal, go to a criminal attorney. That's the first thing, is choose horses for courses. Okay, you might have a friend from school and he was, well, your best friend, he became an attorney. However, he might not be the right player with you in that game. Secondly, very importantly, please never ignore a legal letter or a summons. Take it seriously, because these things run a route, Jeremy, that becomes very, very messy. I would say be patient with the legal process. As Dolph said earlier on, there's a lot of paper, there's a process and a procedure, and that is there to be fair to everybody, to discover documents, to discover evidence, to prepare properly. But be patient. Even though you know and you believe you're right, I promise the other party thinks the same. So it's rather complex. Very important as well. Please never withhold any information from your attorney or your legal representation team. You're holding information back for whatever reason. Okay? They will know how to deal with that information. If you don't share it all, you're not going to get the best representation. And that's a promise. It all comes out in the washing, and it comes at the wrong time. It makes matters far difficult. Understand as well, last 2 points, your attorney, while dealing with you, and your advocate, if the advocate's involved, will lean a lot on the other party's case. They will argue first and go through their minds, what is the other party's case? I know it's annoying for a business or a man in the street, a corporation, when your legal counsel seems to be understanding the other side's argument. That is the best way of preparing your argument and where you fit in. So be patient with that. Work along with it. And finally, when we get to a point where a matter either goes to court or we pray for it, and hopefully it's concluded prior to getting into court. My opinion is a personal opinion only. I wasn't taught this in law school. But if both parties are just a little bit unhappy with the outcome, I think we have a successful outcome. If you have one party that's euphoric and the other party completely down on their knees, I don't think we have a great outcome. It's always good, especially when you're trying, before even pre-trial or pre-trial, to settle the matter without going to court. Always a bit of give and take. There are always two sides to a story. Jim, I hope that helps a bit.
It certainly does. Thank you very much. Advocate Lance Brogden, who is our resident legal expert here on Mansfield today. We'll be back next Tuesday with another look at the legal side of things. Thank you for joining us. It's been nice to be with you. Cheers.